When 11-year-old Lyhanna did not return home from school, an entire town began searching for her. Within hours, investigators were looking at a man who had already appeared in several earlier files involving allegations of sexual violence against children. He had never been convicted in those cases. He had not even been questioned about the most recent complaint. 6 days later, Lyhanna was found dead. The discovery transformed a desperate search in a small French town into a national crisis. People were grieving for a child. They were also asking how many warnings a system could receive before it acted. A mother had previously reported serious abuse involving another young girl. Medical and psychological assessments had supported the need for investigation. A file had moved between prosecutors, been placed in a red folder intended for urgent matters, sent to the wrong police unit, delayed, transferred again, and then allowed to sit without the suspect being interviewed. By the time Lyhanna disappeared on May 29, 2026, those warnings existed in different offices, different computer systems, and different memories. But they had not become protection. France's justice minister would later apologize publicly. The president would call the failures unacceptable. Government inspectors would describe serious weaknesses in the handling and supervision of an earlier complaint. Thousands of people would walk silently through Lyhanna's hometown, dressed in white and carrying flowers. Yet behind every investigation, report, protest, and political promise was one child whose name must not be reduced to a symbol. Before France knew Lyhanna as a headline, she was a daughter, a sister, a student, and a friend. She had a family expecting her home. She had classmates who knew her as a person, not as the center of a national debate. This is the story of Lyhanna Rameau Bernard, the search that gripped France, the institutional chain that investigators say broke down, and the urgent question that remains. When a child may be in danger, how quickly must the system move? For Lyhanna, the answer came too late. Fleurance is a small town in the Gers department of southwestern France. It is the kind of place where a disappearance does not remain private for long. Schools, families, local officials, and neighbors are connected by ordinary routines. A child leaves class. A parent expects her home. When that routine breaks, people notice. On Friday, May 29, 2026, Lyhanna left her middle school in Fleurance. She was 11 years old. She did not arrive where her family expected her to be. As the hours passed, concern became alarm. Her disappearance was reported, and a large search began. Investigators worked to reconstruct the period after she left school. Evidence indicated that Lyhanna had entered a vehicle with the father of one of her schoolmates. The man, 41 years old, was identified quickly. French official documents referred to him by the initials JB, while news organizations have identified him as Jérôme Barella. He remains legally presumed innocent unless and until a court rules otherwise. The distinction matters. This case has generated intense anger, but anger is not a substitute for trial. Police may arrest a suspect. Prosecutors may bring charges. Forensic evidence may strengthen a case. Final criminal responsibility must still be established through the courts. Authorities arrested the suspect on May 30, one day after Lyhanna disappeared. On June 1, he was formally placed under investigation on accusations of abducting and unlawfully confining a child younger than 15. He was ordered into pretrial detention. According to reporting available in July 2026, he denies the accusations. The arrest did not end the search. Lyhanna was still missing, and the immediate objective was to find her. Police and gendarmes deployed personnel and technical resources. Searchers examined roads, fields, buildings, waterways, and rural lands surrounding Fleurance. Local residents joined organized efforts. Her photograph moved across television, newspapers, and social media. Each passing day made the uncertainty heavier. For the public, the search was a developing news story. For Lyhanna's family, every hour was personal. They were not waiting for a press conference. They were waiting for their child. Then, on June 4, search teams reached an abandoned agricultural site outside the town. Inside a disused grain silo, they found a child who was no longer alive. The following day, DNA testing confirmed the identity. It was Lyhanna. The confirmation ended hope and began a different kind of investigation. Medical examiners worked to establish what had happened. Later forensic reporting indicated that Lyhanna had been sexually assaulted before her death. No further detail is necessary to understand the seriousness of the crime. She was a child, and the responsibility belongs entirely to the adult who harmed her. At the time this documentary was prepared, the full cause and circumstances of Lyhanna's death had not been publicly established through a completed trial. The suspect was being held in pre-trial detention and faced accusations connected to her abduction and confinement. The investigation remained active. Those legal limits did not reduce the grief in Fleurance. Flowers appeared outside Lyhanna's school and at community gathering places. People who had never met her followed the news with a mixture of sadness and anger. Parents imagined the ordinary moment of a child leaving school and understood how quickly it had become irreversible. But even before Lyhanna was found, another story had begun emerging. The man suspected in her disappearance was not unknown to the authorities. His name had appeared in previous procedures involving alleged sexual offenses. 2 earlier matters had been closed without prosecution. A third complaint, filed in August 2025, was still open. This did not mean the suspect had been proven guilty of any earlier allegation. It did mean that several official systems already contain warnings requiring careful investigation. The most recent complaint involved another girl who was 11 at the time. Her mother reported repeated abuse and sought action from authorities. The file was serious enough to include specialist assessments and requests for additional investigative steps. The question was no longer only whether police had known the man's name. The question was what happened after they knew it. Why had the suspect not been interviewed about that complaint before Lyhanna disappeared? Why had a case involving allegations against a child moved slowly across offices? Why had separate earlier files not created a clear, urgent warning? The French government ordered inspectors to reconstruct the answer. What they found was not one dramatic decision. It was a chain of delays, transfers, errors, limited staffing, and insufficient supervision. On June 5, one day after Lyhanna was found, the ministers responsible for justice, the interior, and education created a joint inspection mission. It brought together the inspectorates of the justice system, the national gendarmerie, and education. The mission was not asked to determine guilt in Lyhanna's criminal case. Its role was to examine how earlier procedures involving the suspect had been handled and whether institutional failures had occurred. Inspectors reviewed the complete file connected to the August 2025 complaint. Between June 8 and June 12, they conducted 28 interviews with people who had worked on the matter and with their supervisors. They examined the movement of documents, the instructions given by prosecutors, the work of gendarmerie units, and the systems used to monitor unfinished cases. The preliminary report divided the history into 2 broad stages. First, it found that the Toulouse prosecutor's office and the initial gendarmerie unit handled the complaint with meaningful investigative activity. Then the case was transferred because the alleged acts and the suspect's residence fell within another jurisdiction. That transfer took the file to the prosecutor's office in Auch. Jurisdictional transfers are normal. Criminal cases often move to the office legally responsible for the place where an offense allegedly occurred. But a transfer creates risk. The sending office may believe its work is finished. The receiving office may not yet understand the urgency. If records arrive through several channels, responsibility can become unclear. In this case, the report said that the transition was imperfect and that the handling later became deficient. The file was registered at Auch in October 2025. Lyhanna would disappear more than 7 months later. During that interval, the suspect was not taken into custody or questioned about the August complaint. The file itself became a symbol of the problem. On December 2, it was given to a magistrate in a red folder reserved for urgent matters. But the color of a folder cannot create urgency if the system around it does not act. More than a month passed. On January 9, 2026, instructions were issued to continue the investigation, question the suspect under formal detention, and obtain a psychiatric assessment. Those instructions showed that important action was expected. But they were sent to the wrong gendarmerie unit. The mistake was discovered on January 21. The file was redirected and reached the relevant local network the next day. Inspectors calculated that the error added another 13 days of delay. 13 days alone did not explain the entire failure, but they became one part of a much longer pattern. A red folder had moved. An order had been written. A digital transfer had been made. Yet the central action still had not occurred. The suspect had not been questioned. When the file reached the Fleurance area gendarmerie network, another warning should have become visible. An officer recognized the suspect's name from a similar procedure handled in 2024. That recognition could have connected the active complaint with an earlier file. According to the preliminary report, the earlier archived procedure was not retrieved, and the school environment relevant to the allegations was not properly examined. Inspectors described the later investigative steps as minimal. They also found that responsibility for the file became too concentrated and that supervisory systems did not function effectively. Review mechanisms that were supposed to identify delayed cases did not produce the necessary intervention. This was not simply a story about one forgotten sheet of paper. It was a story about information that existed but failed to become action. One office knew about an earlier complaint. Another office had the new file. An officer recognized the name. A prosecutor had ordered an interview. Guidance told investigators to prioritize violence against children. But no part of the chain successfully forced the case forward. The report also described a system working with serious resource constraints. The local Fleurance unit had fewer personnel than its official staffing level. Across the first half of 2026, it was short by roughly 5 to 7 positions. Officials were managing many investigations with limited time and competing priorities. Staffing shortages help explain how delays occur. They do not make the consequences disappear. A system can contain hard-working individuals and still fail as a system. That was one of the most uncomfortable findings. There did not need to be a single official who deliberately ignored a child. Protection could fail through a sequence in which each person completed only part of the task and no one ensured the entire task was completed. This distinction is important because public anger often searches for one person to blame. One prosecutor. One officer. One administrator. But replacing one person does not repair a system that allows urgent cases to become ordinary files. At the same time, calling a failure systemic must not become a way of avoiding accountability. Systems are made of decisions. Someone sets priorities. Someone supervises unfinished work. Someone decides whether staffing is sufficient. Someone designs the software and transfer process. Someone must notice when a suspect named in several child protection files has never been interviewed. The preliminary report showed how the protection chain broke. The national debate then turned to whether France would rebuild it. On June 7, 3 days after Lyhanna was found, the people of Fleurance gathered for a silent march. Local authorities estimated that about 6,000 people attended, roughly equal to the population of the town itself. Lyhanna's parents joined the procession. Her relatives, classmates, neighbors, and strangers walked beside them. Many participants wore white. Some carried white flowers. The march was intentionally silent. There were no chants needed to explain the grief. At the front, a banner carried Lyhanna's name and a promise that the same failure must never happen again. The family asked national politicians not to turn the march into a political event. That request mattered. When a case becomes nationally important, officials, commentators, and campaigners can begin competing to define its meaning. For the family, Lyhanna was not an argument. She was their child. The gathering ended near the school she had left just over a week earlier. The location connected the final public farewell with the ordinary routine that had been interrupted. A school should represent safety, learning, friendships, and a future. Now it stood at the center of a national demand for protection. Inside France's National Assembly, lawmakers observed a minute of silence. Members from different political parties described the death as a failure of the Republic's duty to protect children. The debate became fierce. Some demanded resignations. Others warned that punishing individuals without funding and restructuring the justice system would change little. Justice Minister Gérald Darmanin publicly apologized to Lyhanna's family and to the French people. He acknowledged that the judicial system had failed to protect her. President Emmanuel Macron said officials could not look at the family and pretend everything had worked properly. Prime Minister Sébastien Lecornu asked whether the warning signs had been handled quickly enough and whether the correct priorities had been set. Those statements were unusually direct. Governments often wait for final reports before admitting failure. In Lyhanna's case, the timeline already made denial impossible. A serious complaint had remained unresolved. The suspect had not been questioned. Then a child disappeared. An apology recognized the failure. It could not answer the larger question. What would prevent the next urgent file from waiting in another office? The national response began with reviews and promises. Officials called prosecutors together to examine how cases involving sexual violence against children were prioritized. Advocates demanded mandatory deadlines for investigative steps, stronger information sharing between jurisdictions, and automatic review when the same name appears in multiple child protection cases. Child protection organizations also argued for emergency legal tools that would allow prosecutors and judges to act before a long criminal investigation is complete. The purpose would not be to declare a suspect guilty without trial. It would be to reduce immediate risk while allegations are investigated. In domestic violence cases, protective orders can separate a potentially dangerous adult from a person at risk. Advocates asked why similar urgent protection could not be made easier when a child reports sexual violence. The challenge is legal as well as practical. Authorities must protect children while respecting the rights of people who have not been convicted. Those duties are not opposites. A temporary protective measure is not a criminal sentence. A prompt interview is not a declaration of guilt. Connecting records is not prejudice. It is responsible investigation. Another demand concerned resources. Files do not investigate themselves. Mandatory deadlines become meaningless if prosecutors and gendarmes have more cases than they can safely manage. Digital systems do not solve problems if important information is divided across platforms or if staff do not have time to review alerts. Lyhanna's case demonstrated that urgency must be operational, not symbolic. A red folder is symbolic. An assigned investigator with time, supervision, and a clear deadline is operational. A policy saying children are a priority is symbolic unless delayed cases automatically rise to the attention of a supervisor. A ministerial promise is symbolic unless budgets, staffing, training, and accountability follow. France had already been debating its response to sexual violence against children. Parliamentary investigators had heard from families who said they struggled to make institutions believe and protect children. Lyhanna's death gave those warnings a name recognized across the country. But the purpose of reform cannot be to use her name for a few weeks of attention. It must be to change the path of the next report from the moment a child speaks. Listen. Record. Connect. Investigate. Protect. If any link waits indefinitely, the entire chain may fail. There is also a responsibility for the media and the public. True crime coverage can bring attention to institutional failures, but it can also turn a child's death into entertainment. Lyhanna's photograph should not become decoration for speculation. Her family's grief should not be treated as content to be repeatedly consumed. Responsible coverage avoids graphic details. It does not invent final moments that no witness can verify. It does not publish rumors about the family. It does not treat an accused person as legally convicted before trial. And it does not identify other children who made allegations when the law and basic decency protect their privacy. The earlier complainants in this story matter. Their reports form part of the institutional history. But they are children, not supporting characters in a public mystery. The official inspection report protects them with letters rather than names. Any responsible retelling should do the same. The suspect's legal rights matter as well. He has denied the accusations. The investigation must establish admissible evidence, the defense must have the opportunity to challenge it, and a court must decide guilt. Presumption of innocence does not require silence about institutional failures already documented by inspectors. It requires accuracy about what has and has not been proven. Several facts are confirmed. Lyhanna disappeared after school on May 29. The suspect was arrested the following day. He was formally placed under investigation for abduction and confinement on June 1. Lyhanna was found on June 4 and identified by DNA. An earlier serious complaint involving the suspect had not resulted in his questioning before her disappearance. Government inspectors found deficient handling and supervision after the case moved to outrage. Other questions remain for the criminal investigation and future court proceedings. What exactly occurred after Lyhanna entered the vehicle? What evidence will prosecutors present? How will the defense respond? Will the charges be expanded or changed? What will a court ultimately decide? A compelling documentary does not need to pretend those answers already exist. The confirmed timeline is powerful enough. Lyhanna's case has been described as a failure of justice, policing, child protection, administration, and political leadership. In truth, it touched all of them. A prosecutor's office cannot act without investigators. Investigators cannot connect files they cannot access or do not review. Schools cannot report concerns if staff are not trained or if legal reporting duties are unclear. Leaders cannot call child protection a priority while leaving local services understaffed. The phrase protection chain is useful because it shows dependence. A child may speak first to a parent, teacher, doctor, counselor, or police officer. That person must know what to do next. The report must reach the correct authority. The authority must assess urgency. Investigators must gather evidence. Prosecutors must supervise. Judges may need to impose protective measures. Each link must assume that delay has consequences. In the earlier complaint examined by inspectors, people did take some correct steps. The mother reported the allegations. Specialists assessed the child. The Toulouse authorities conducted investigative work. Instructions were eventually written to question the suspect. The tragedy is that correct steps remain separated from one another by delay. This is why reform cannot depend only on finding more courageous families. Families had already spoken. The system had already received information. The missing element was a structure that converted the information into timely action. Nor can reform promise that every accusation will be proven. Some investigations will end without charges because evidence is insufficient. That is part of justice. But there is a profound difference between investigating a complaint and finding insufficient evidence, and allowing a complaint to remain unresolved because the responsible institutions did not complete the essential work. Lyhanna's case brought that difference into national view. France was not only asking whether one suspect should have been stopped. It was asking whether children are believed quickly enough, whether patterns are recognized early enough, and whether institutions understand that lost time can become lost protection. The preliminary report was an important beginning. It was not the end. Further inspection work, the continuing criminal investigation, and the government's promised reforms all remained unfinished when the story was written. One lesson from this case is that child protection cannot wait for the final day of a criminal trial. A trial determines guilt and punishment. Protection begins much earlier, when officials assess risk and decide which precautions are justified while evidence is still being gathered. That does not mean every allegation should lead automatically to imprisonment. It means every serious allegation should lead to timely, documented decisions. Was the child interviewed by trained specialists? Was medical evidence reviewed? Was the accused person questioned? Were earlier reports located? Were other children potentially at risk? Did a supervisor check whether the essential steps were completed? In Lyhanna's case, the preliminary report did not say that officials should have predicted every future event with certainty. It documented that an existing investigation had not received the priority, supervision, and progress its seriousness required. That is a narrower conclusion than criminal guilt, but it is still a profound one. Institutions are often judged by their written rules. Children experience institutions through what actually happens. A promise to prioritize minors means little if an urgent file waits for months. A reporting procedure means little if separate warnings are never connected. A right to protection means little if no one is responsible for checking that protection occurred. That is why Lyhanna's story reaches beyond one town and one investigation. It asks every justice system whether its protections exist only on paper or whether they work at the moment a child needs them. On the day of the silent march, the streets of Fleurance were filled with people, but almost no sound. The silence carried grief, anger, and a promise. Lyhanna's family walked through the town where she had gone to school, made friends, and lived an ordinary childhood that should have continued. That ordinary childhood is what must remain at the center of the story. Not the suspect's biography. Not the most disturbing detail. Not the competition between political parties. Lyhanna was more than the event that ended her life. The public may remember the silo, the red folder, the unanswered complaint, and the 13-day transfer error. Those details matter because they reveal how institutions failed. But the reason they matter is Lyhanna. A child should have returned home from school. The case now presents France with 3 tests. The first is legal. Investigators and courts must establish the truth fairly, protect the rights of all children involved, respect the accused person's right to a defense, and reach a judgment based on evidence. The second test is institutional. Government promises must become working procedures. Urgent complaints must be tracked. Repeated names must trigger review. Transfers must preserve priority. Supervisors must see delayed cases. Local offices must have enough trained people to perform the work. The third test is cultural. Adults must listen when children speak. Institutions must resist the assumption that a child's account can wait. The public must demand accountability without turning grief into harassment or abandoning the presumption of innocence. These tests will not be passed by one report or one speech. They will be passed case by case, deadline by deadline, whenever an official chooses to treat a warning as urgent. Lyhanna's name has already changed the national conversation. Whether it changes the system will depend on what happens after the marches end and the cameras leave Fleurance. A red folder should never again be mistaken for action. A policy should never be mistaken for protection. And a child's warning should never be allowed to disappear between offices. Lyhanna was 11 years old. She should be remembered with dignity, not reduced to the crime committed against her. Her family deserves truth. The other children who spoke deserve protection. And every institution that received a warning must answer the question France is now asking. What will you do before another child fails to come home?